Hello, everybody. This is Frank with Iron Age News. It is Thursday, January 29th at noon. And for those of you in Philadelphia, my old hometown, District Attorney Larry Krasner, the guy with one of the worst prosecutorial records ever, has decided to come out against the federal agencies running ICE and everything else, warning you that he is going to arrest ICE agents and there's nothing that anybody can do about it, et cetera, et cetera. But he's wrong. And let's talk about something. I am fresh off of having just filed a complaint with the Pennsylvania Bar Association against Krasner just for this purpose. It's got to be, somebody has to do it, and it has to be done now. We're talking about selective prosecution is a civil rights problem, even when it's politically fashionable. So, American civil rights law was not written solely to correct past injustices. It was written to prevent a recurrence in new forms. Okay. One of the most enduring lessons of the Jim Crow era is that civil rights violations often do not arise from openly unlawful statutes, but from selective enforcement by officials cloaked in discretion. The Philadelphia District Attorney Larry Krasner's recent statements regarding the prosecution of federal immigration officers raised precisely that concern. This is not an allegation of racism nor a claim of criminal misconduct. It is a civil rights warning grounded in history and law. The selective use of prosecutorial power to intimidate a disfavored class out of lawful employment is an abuse the Constitution was designed to prevent. So let's talk about selective enforcement, not policy disagreement. Prosecutors are entitled to policy views. They are not entitled to weaponize criminal process to advance those views. Mr. Krasner has publicly announced an intent to pursue state criminal charges against a specific identifiable class, federal immigration officers, while framing their lawful professional duties as presumptively suspect. He has further emphasized that such prosecutions would be immune from presidential pardon, a statement that is legally accurate in isolation, but it's misleading in its context, as it implies criminal exposure for conduct which has long been protected by Supremacy Clause immunity. The problem is not the abstract legal proposition that state crimes can be prosecuted. The problem is prejudgment. When a prosecutor publicly signals that a particular class of lawful actors is a target before the facts, cases, or individual conduct are assessed, the prosecution ceases to be neutral. It becomes deterrence by intimidation. So let's give you the historical parallel. All right. During Jim Crow, the Jim Crow era, prosecutors rarely needed openly racist statutes to achieve discriminatory ends. They relied instead on factual neutrality, discretionary charging, selective law enforcement, public signaling meant to chill lawful conduct. The harm was not merely wrongful conviction, it was economic and professional destruction, lost livelihoods, constant legal jeopardy, and the deterrence of lawful activity through fear of prosecution. Modern civil rights doctrine recognizes that deprivation of livelihood through discriminatory enforcement is a constitutional injury, even absent conviction. That principle applies regardless of the political popularity of the target. Federal law enforcement officers continue to constitute a discrete and identifiable class. Singling them out for prosecution based on disagreement with federal policy rather than individualized criminal conduct raises serious civil rights concerns. The constitutional line prosecutors cannot cross. The Supremacy Clause exists to prevent precisely this outcome. 50 local vetoes over federal law through harassment, and prosecution. Courts have consistently held that federal officers acting within the scope of lawful duties are immune from state criminalization. Attempts to circumvent that protection through selective charging do not advance accountability. It erodes the constitutional order. Civil rights enforcement is not defined by the popularity of its beneficiaries. It is defined by whether power is exercised evenly, neutrally, and in good faith. Accountability does not mean politicized prosecution. If a federal agent commits a crime outside lawful authority, prosecution is appropriate. If a prosecutor announces in advance that a class of federal officers will be targeted as a matter of policy, accountability gives way to coercion. History teaches that the danger lies not in one prosecution, but in the precedent such tactics normalize. Civil rights are not progressive or conservative, they are structural, and selective prosecution, no matter how rhetorically justified, remains one of their oldest enemies. So that's what we have to say on that. If you were anyone in the United States and would like to draft a Pennsylvania bar complaint against the District Attorney of Philadelphia, Larry Krasner, you're more than welcome to do so. If there are any questions, you can contact us, and I'm sure we can find somebody who will help you go through the process. You can either send one in via the mail, or you can go online and do so. You do not even have to be a citizen of the state of Pennsylvania to do so if you know that what is going on is detrimental to the Pennsylvania bar, lack of a better term. All right, so that's all we have for you today on this one. Krasner is not helping the city of Philadelphia in any way, shape, or form. For those of you who are just tuning in, by the way, and you were worried about Philadelphia law enforcement, the sheriff of Philadelphia is not the chief of police of Philadelphia. They are two different organizations. Her organization is not law enforcement on the street. So when she runs her mouth and you hear that tooth flapping, she is not the Philadelphia Police Department. Although their management hasn't really come out either. So shout out to the rank and file who have to put up with this nonsense on a daily basis. Talk to you all later on.